Good evening, everyone, and welcome. I'm Jennifer Mnookin. For those who don't know me, I'm the dean here at UCLA Law School, and I'm very excited to welcome all of you to Whither the Court. I want to welcome you in groups tonight, in a way. I want to welcome all of the students who are in the room. I want to welcome the alums who are in the room, whether it's your reunion year or otherwise. I want to welcome the faculty who are here, and I especially want to welcome Linda Greenhouse, the New York Times former Supreme Court reporter, one of the most esteemed journalists in the nation, to join us tonight at UCLA. Now, this is a pretty auspicious time for an event like this. And I'm not only referring to the fact that the Supreme Court has been on all of our minds, I think, for much of the day yesterday and today and in the weeks coming up to right now. This year's meeting also takes place just 3 days before the Supreme Court kicks off its new term. And it also takes place just 1 day after we at UCLA Law had a terrific visit yesterday from Justice Elena Kagan. She was here and met with our students, faculty, and some of our alums as well in a series of illuminating talks, although she did not talk about yesterday and today's events, but we were incredibly appreciative of her time and effort and insights. And so it's feeling not only like it's Supreme Court week in the entire universe, but it's Supreme Court week here at UCLA, and we're really pleased about that. I do want to talk very briefly about how tonight's program fits into our work at UCLA Law School, because we talk about the court, obviously, not just at events like this, but in many ways, the court's deeply ingrained in our engagements. One of those is that we have a Supreme Court clinic, which under the banner of Professor Stuart Banner has achieved tremendous success in recent years. We've had 7 merits cases at the court in the past 3 terms alone, which is one of the highest numbers of merits briefs of any Supreme Court clinic in the country. And 2 of them Stuart argued himself. He was previously clerked for Supreme Court Justice Sandra Day O'Connor. And so his students get to work on new cert petitions and briefs, both merit briefs and sometimes amicus briefs, and those efforts are a real highlight of our curriculum. In fact, faculty members from across the law school regularly file amicus briefs in cases before the Supreme Court, and often there's substantial research effort from students as well. Last term, there were actually 3 UCLA-related briefs in the Masterpiece Cake Shop case from members of our community. The Williams Institute for Sexual Orientation and Gender Identity in the Law had submitted 1 brief, as did our professors Shauna Schifrin and Eugene Volokh. Then in another case that wasn't quite as high profile, called Hughes versus the United States, our own Professor Richard Ray filed an amicus brief that was actually cited an incredible 10 times by the justices and lawyers during oral argument. And that was so many and so unusual that there was a tiny bit of press, not so much about the underlying issue in the case, but about the fact that Richard Ray got cited that many times in oral arguments. So that was pretty cool. As just one more example, Professor Sean Hecht and his students affiliated with the Emmett Institute on Climate Change and the Environment filed an amicus brief in an Endangered Species Act that's going to be heard very soon, Weyerhaeuser Company versus the U.S. Fish and Wildlife Service. So it's terrific that our students and our community get to be engaged in these kinds of cases. Now, tonight's event, Whither the Court, has long been one of the highlights of our calendar. The formal name is Whither the Court, the Allan C. Lebow Annual Supreme Court Review. And that's in honor of an exceptional alum of this school. Allan Lebow was a tremendous student who then went on to phenomenal professional accomplishment as well. He earned a bachelor's degree in political science from UCLA in 1969 and excelled in law school, serving on the UCLA Law Review and in our trailblazing program at the Center for Law and Social Policy in Washington, D.C. He practiced corporate and bankruptcy law in Southern California and made a name for himself both there and for the extraordinary person that he was, brilliant, humane, and generous, but then had a far too untimely death in a plane crash when he was traveling to a court appearance. His family made a gift endowing this event in his honor. And so I want to, he's also mentioned in your program, but I wanted to tell you about that as well. Allan's widow, Cindy, is also an incredible alum of UCLA Law and a dedicated supporter of her alma mater. She's standing right behind this door, but I think she should come out. So come on out, Cindy, and let's give you a round of applause. Cindy also has a reunion year this year, and tonight she's going to do us the honor of introducing our wonderful panel. So with thanks, Cindy, for all of the ways that you're involved at the law school, and with many thanks to all of you, Whither the Court.
Thank you, Dean Mnookin, for your kind words and kind introduction. But most importantly, I hope she can hear me. Let me thank you for your unwavering and enthusiastic support for the Whither the Court program as it has evolved and flourished over the past 4 years. With the inclusion of the annual Supreme Court review as the showcase event of Alumni Reunion Weekend, we have achieved the visibility. Just look at how many people are here. That such an extraordinary program so richly deserves. You have brought the energy and leadership, Jennifer, to this project that you have brought to all of your endeavors here at the law school, and we thank you. It's UCLA Law on the move. First, as Jennifer said, I have to give a little shout out to the class of 1973. Yes, it's true. It's our 45th reunion. It's a number I can barely get out. Yeah, fake news. My students, I teach in the political science department here at UCLA. I teach the constitutional law and Supreme Court classes. And my students are often asking me, well, now, Professor, what year did you graduate from law school? Thinking that I would say, right, thinking that I would say something like, oh, you know, in the 80s or early 90s. And when I tell them, they whip out their smartphones and go like this. And then they go, no. Professor, how can that be? So I figure if I'm still pulling that off, I'm doing well. But it's hard to believe that so much time has slipped by. Just for a second to think of the highlights of 1973, but many of them are still with us. The Watergate hearings began in 1973. We all watched them in the one television set across in the law school in the student lounge.
Apparently they're still going on because the TV in the lounge is still, then all the students are.
The Supreme Court issued its historic opinion in Roe versus Wade. Couldn't be more topical today. Billie Jean King beat Bobby Riggs in the Battle of the Sexes. The Endangered Species Act, Anne, was passed in 1973. And of course, most importantly, UCLA won its 9th NCAA men's basketball championship under Coach John Wooden. That championship was actually the 7th straight championship. Oh, those were the days. But speaking of history, we are living through it today, this very night. What a moment in time to contemplate Whither the Court. I'm sure that all of you have been glued to your TVs or your smartphones or your iPads as the incredible drama of the Kavanaugh nomination has played out. There simply couldn't be a better evening to think about the decisions of this past term and the issues that lie ahead. This past year, the court opined on issues as diverse as cell phone privacy, the First Amendment rights of public sector employees, the status of sports gambling under principles of federalism, and the national security powers of the president under the nation's immigration laws. There were a couple of non-decisions, like the Masterpiece Bake Shop case, and the decision not to decide the constitutionality of partisan gerrymandering. At the moment, the caseload for the term that begins on Monday seems relatively benign, but we know that waiting in the wings in the courts below are critical cases on reproductive choice, affirmative action, and religious freedom, to name just a few. So let's get to it. In the interest of time, You can all read the lengthy biographies that are included in your program. I'm going to keep these introductions short. Let me first introduce our panelists from the UCLA School of Law. The idea is Adam's going to moderate a kind of a roundtable discussion on a variety of topics, so I'm not going to introduce the speakers like they're going to speak in a particular order. First, Devin Carbato. Devin was most recently named the Associate Vice Chancellor for Equity, Diversity, and Inclusion, and he is the Harry Pragerson Professor of Law. He teaches employment discrimination, criminal law, constitutional law, and critical race studies. Currently, he is doing a series of articles on race, law, and police violence. And I'm just going to say from personal experience, and Devin, I don't mean to embarrass you, but he's one of the nicest people you'll ever meet. Next, Ann Carlson. Ann teaches property, environmental law, climate change law and policy, and climate and energy law workshop. Most importantly, she is the Shirley Shapiro Professor of Environmental Law and the inaugural faculty director of UCLA's Emmett Institute on Climate Change and the Environment. Simply said, she is one of the nation's leading scholars on climate change and policy. She agreed to be with us tonight while she is awaiting a phone call from the Trump administration. Just kidding. Probably not. Probably not. Right? Probably not. All right, our next speaker, our next faculty member is Hiroshi Motomura. Hiroshi is, in a word, amazing. I have been at briefings and programs that you have given, and you're just amazing. He is a teacher and scholar of immigration and citizenship, but that doesn't begin to tell the story. He has testified many times before Congress, litigated many important immigration cases, and is a member of the American Bar Association's Commission on Immigration. In 2008, he was an advisor to the Obama-Biden Transition Team Working Group on Immigration Policy. Last year, he was awarded a prestigious Guggenheim Fellowship to work on a book, The New Immigration Law. He's also waiting for a phone call from the White House. Finally, our moderator, Adam Winkler. Adam is an expert in constitutional law and the Supreme Court. In 2011, his book, Gunfight, The Battle Over the Right to Bear Arms, was a national bestseller, and you can frequently catch him on NPR and other media outlets talking about gun rights. But most importantly, and Adam, congratulations, his new book, We the Corporations, How American Businesses Won Their Civil Rights, was just listed for the National Book Award for Nonfiction. That is, in the terms of my former boss, Joe Biden, a big deal. Adam's scholarship is so accessible, and We the Corporations, which I read this summer, is a book I can recommend to everyone, whether you are a lawyer or not. I have to say, Adam, thank you for all the hard work you and your staff, Elsa, and the people who work with her in getting this program organized and put together. Finally, Linda Greenhouse. Last but certainly not least, our keynote speaker. For more than 30 years, Linda was the Pulitzer Prize-winning Supreme Court reporter for the New York Times. She covered 29 terms, is that right, Linda? Of the Supreme Court from 1978 to 2007. She has published more than 2,800 articles in the New York Times. Retiring from her daily reporting duties in 2008, Linda is now the Joseph Goldstein Lecturer in Law at Yale Law School and is also the Knight Distinguished Journalist in Residence. She continues to write a bi-weekly column on law for the Times, which I always eagerly look forward to reading. She has written many important books on the Supreme Court, including my favorites, which I would highly recommend, Becoming Justice Blackmun, incredible book, and a book called A Very Short Introduction to the Supreme Court, published by the Oxford University Press, which Linda, I make all my students read. It is an extraordinary confluence of luck and timing that she is with us this weekend and tonight. to opine as to whither the court. There is simply no way that I can thank you enough for traveling across country to be with us on this occasion. Thank you so much. Without further ado, Adam, I'm going to turn the mic over to you.
Thank you. Thank you very much. Thank you, Cindy. That was wonderful. As everyone's noticed, it's a pretty big week for the Supreme Court. And surprisingly, if we were doing this event and these confirmation hearings had not been happening, we'd still be talking about this being a really important moment of transition for the United States Supreme Court, above and beyond what we've been witnessing this week and how it might affect the court. The court's at a turning point in a number of ways. It's in a turning point in terms of its personnel. Justice Kennedy has retired after 12 years as the swing justice on the Supreme Court. And former Justice White said that anytime a new justice joins the Supreme Court, it's a whole new court. And whether it's Brett Kavanaugh or whether it's someone else, the Supreme Court is likely to undergo a significant change in the next year in its personnel. The court's changing in terms of its doctrine. Because that Justice Kennedy is going to likely be replaced by someone appointed by President Trump, whether Brett Kavanaugh or someone else, we're likely to see pretty substantial shifts in the law going forward, where we have in areas ranging from the environment and free speech, executive power, affirmative action, reproductive rights, we're likely to see some big changes, whether Brett Kavanaugh is the appointee or not. Those changes are a good chance they're going to come. And I think in some ways the institution of the Supreme Court may itself be at a moment of transition. So many institutions have lost the respect of Americans. And when we think about public approval rates of Congress or the presidency or mainstream media or other major institutions, often the approval ratings are very, very low. But the Supreme Court over the years has mostly maintained its high approval rating in the eyes of the public. One can only wonder how the events of this past week will impact that going forward, if indeed it will. But the court may itself and its position in the public mind may be changing too. And so I can't imagine a better group to have on stage to talk about some of these issues than my three wonderful colleagues and Linda Greenhouse. Linda, I was thinking about if you covered the court for 29 years, and you've really still been covering the court for the 10 years since, right? So that's 39 years. That's longer than any Supreme Court justice has ever served. And I think it may be fair to say that no one knows more about the Supreme Court than Linda Greenhouse. And if there is anyone, it's only the 12 people who've actually served as justices on the Supreme Court who are still alive today. 8 justices and 4 who are retired. And so it seems appropriate just to start with you, Linda, and to ask about this week that we've been through, and how do we put this in some kind of perspective with your experience from the Supreme Court all these years.
Oh, thanks, Adam. And I'll just say to Cindy and I go back to both of our Washington days when she was counsel to Senator Biden. And it's good to see you. And Cindy, if it makes you feel any better here at your 45th reunion. So I recently attended my 50th college reunion. And as I was checking in at the desk to get my gala and everything, I felt like shouting to the undergrads who were there helping, the old folks check in, I'm not as old as you think I am. But of course, I realized I was precisely as old as they knew I was. Because they've been hired to work at the 50th reunion, so you have that to look forward to. But in answer to Adam's softball, so watching these events unfold, including this morning. So I'm assuming everybody knows what went down this morning, right? So, okay, I sat there thinking, imagining I was John Roberts, Chief Justice Roberts, and what is he thinking? And that, in a way, is kind of the key to whither the court, whether his new colleague is Brett Kavanaugh or another Trump-appointed justice, because with the departure of Justice Kennedy, who, as Adam said, was the median justice, the swing justice, in a group of 9, somebody's always in the middle. And, is it going to be John Roberts? And how is he going to use that position? He's a very conservative individual. He's got his projects. One is to, I think a main one, is to get the government out of the business of ever putting a thumb on the scale on behalf of race. He's the justice who wrote the Parents Involved case. In 2008, he's the justice who wrote Shelby County, which cut the heart out of the Voting Rights Act. And there's no way he's not going to take the opportunity to advance that project. I think increasing the space for religion in the public square. He's written a couple of important opinions that sort of go down the road and further eviscerating what remains of the Establishment Clause. I think that's another Roberts project. So he's got to wonder, given that the court has been tossed into the political thicket, not to coin a Supreme Court phrase, with the high profile and the cringe-making aspects of the last couple weeks. We know he cares a great deal about the court and, of course, his legacy. It's the Roberts Court, and he's very aware of that. And how is he going to respond? And that's a bit of the answer. And I'll just say one more thing. I don't want to hog the microphone here. And we're going to eventually, in this program, talk about some cases. And Adam is going to do a deep dive on the Janus case, the labor case that accorded a First Amendment right to anti-union workers not to have to pay their fair share of the union dues that go to the collective bargaining activities that benefit everybody in the workplace. That case reached the court. We'll go into it more a little bit later, but I want to use it for a different point. At the very time when the public seems to be waking up to the utility of organized labor, especially in the public sector. Remember, late last spring, early this summer, there were teachers going on strike across the country, including in some very red states, saying we need better pay, we need better benefits, and they were prevailing. So here's the Supreme Court going in one direction, really disabling public sector unions, which is the only part of the organized labor movement that has any robust growth at all left, at a time when the public is thinking, unions really are something that help us. And it's this divergence between the center of gravity of the court, which is obviously going to be driven even further to the right, and deeper trends within the American political culture right now that I think is going to present a real challenge to the court. Is going to be extremely interesting.
No, that's fascinating. Can I ask you too to think about how do I think at the top of everyone's minds really these hearings and what we saw the last 2 days. And I don't know about all you. I didn't get any work done the last 2 days. I had big plans to get stuff done. And nothing happened. And I imagine Hiroshi, who's famous for billing his time, even when he's doing personal stuff, he does. He keeps track of it all, and I wish I did the same because he's very productive.
Just keep a diary, Hiroshi.
Right. I bet if you looked at his timesheet, it would be a lot of watching those hearings because we were all so fascinated by them. Linda, you covered 1991. You were covering the Supreme Court. You were in the midst of it when the Clarence Thomas hearings happened. How does what we saw this week compare to the Clarence Thomas hearings?
Well, of course, on the surface, it compares a lot, and it compares even more than it had seemed to when yesterday we heard Brett Kavanaugh's opening statement of the renewed hearing, which he was really, channeling Clarence Thomas, and it was kind of head snapping. And I remember the morning that the Anita Hill story broke, and people often forget that it came after the whole initial hearing had concluded and the committee had voted a tie vote, 7-7, at that time to send the Clarence Thomas nomination to the floor, and Walter Dellinger, very esteemed law professor from Duke and Washington inside practitioner, came running into the Supreme Court press room saying, "What do you think? What do you think?" And I remember I said, "Walter, I think no good will come of this." And, various things came of it, and some of them were good. Obviously, the sort of year of the woman and the wake up. But in terms of the Supreme Court, I think it's very hard to say that any good came of this. I'm as much at sea as everybody here. I don't know what's going to happen with this deferred floor vote, but the toxicity that just was flowing in the committee room, whether he's the next justice or somebody else, it's going to be very hard to put that back in the bottle. And I think, it's part of the atmosphere that we're all living in the age of Trump, really. There was a story in one of the legal press online just before I came over here that a partner in a major Washington law firm had to apologize and erase his Twitter account because he had tweeted after Sarah Huckabee Sanders had said something nice about Brett Kavanaugh, that something to the effect of he'd like to see her head blown off. And how would a sound person in the inside of Washington law practice on his Twitter feed say such a thing? And I think it's because everybody is just going, kind of nuts. The tension is so thick in Washington. It's so good to be 3,000 miles away.
Welcome. Well, you're welcome here anytime, of course.
I mean, that's kind of my not terrifically coherent reaction to the events of the last couple of days. But the notion that, the Republicans have this nominee, and, after keeping a Supreme Court vacancy open, depriving President Obama of the opportunity to name somebody to the Scalia seat for the better part of a year, that this had to be rushed through in a matter of days and hours. It ultimately didn't fly, but it may fly yet, and we'll all live with the consequences.
And I know from running into you in the hallways yesterday that you were watching these hearings quite closely. What was your takeaway?
Well, so let me just start by saying it's been a surreal couple of days. I don't actually follow the Supreme Court that carefully, except on, can you hear me? Okay. On environmental and some administrative law questions. And yesterday, as Dean Mnuchin said, Elena Kagan was here, and we had a faculty lunch that began as Brett Kavanaugh's testimony started. And I left my phone in my office because I knew I couldn't stay off of it, even with her riveting remarks, if I brought it with me. And we spent 2 hours with her, and no one raised it because it seemed inappropriate for a sitting justice to be commenting on it. But one of the things that I think is important to say is not just that it's been riveting, but I have found it extremely painful. Extremely painful, and I think I'm not alone. And it's partially painful because, like many women, I've experienced sexual assault, and I kept it private until today, or until a few days ago. And I think that's true for many, many women and some men. And I think it's important to acknowledge, and for me to really celebrate and recognize the bravery and courage of people like Dr. Ford, who I think was extraordinary yesterday, no matter what the outcome. I think it's important to recognize Maria Gallagher, who today confronted Senator Flake and may actually have changed the course of history in expressing her own views about the importance of making clear that this is painful and it is sending a message to women about how well we are listened to. I think it's important to many women who have written about their experiences, never before revealing them. Today, there was a column published in CNN by a Vermont law professor, Jennifer Taub. A close friend of mine, Caitlin Flanagan, wrote about her own experience in the Atlantic. And no matter what happens, I hope these experiences actually help to change the future for women by making it much more, much safer, not only to express what happens to us on a way too regular basis, but also to really expose what happens and make it stop. And I want to say one more thing about Anita Hill, because I was a young lawyer in 1991 in private practice, Actually, one of my old friends is sitting here in the audience who I knew in those days, and we were riveted to those hearings, and they were just as painful. And she was a trailblazer, and she changed the lives of many, many women, including me, including how I navigated my own professional life. I was the victim of a very big sexual harassment kind of experience, and I actually went and confronted the administration and entered into a settlement agreement as a result. That would not have happened but for Anita Hill. And so I think it's just important in this moment not to forget the really important human impact this is having, the toll it's taking on a lot of women, and hope that in the future this really actually makes a difference regardless of what happens to Judge Kavanaugh and whether he's confirmed or not. So I'll stop there, but it's been a hard few days.
Devin, as the Associate Vice Chancellor for Bruin X, and you're dealing so much with diversity issues, equality issues, anti-discrimination issues, those issues were certainly very much at the surface of these hearings this week. How did you take it? What was your sort of perspective, especially from the perch that you have?
So, I think it's fair to say that I'm still processing the moment, and I wish I could say that I could articulate out aloud a coherent way of making sense of it. Instead, what I think I have is a set of disaggregated views that I'll share with you for whatever they're worth. The first is, which doesn't directly bear on my role at UCLA, but my role as a person who teaches constitutional law, is that it's easy to think of this particular moment, as a moment of exceptionalism, as a moment in which we will see a newly minted conservative Supreme Court, and that's going to effect radical change. That sounds descriptively right to me. Some of you may be happy with that, some of you are not, but descriptively that sounds right. But what I want us to pause and think about as well is the extent to which, at least from a progressive perspective, an awful lot of civil rights ground has already been lost. And I think we sometimes forget that, by which I mean, if the Supreme Court were never, ever, ever, ever to decide another case, the scales of constitutional law are tipped heavily in the direction of maintaining and entrenching rather than disrupting and ameliorating patterns of racial inequality. And I think it's really critical that we understand that loss. The second thing I would say that when I think about this hearing is that it's a context in which we see the good guy, bad guy dichotomy, by which I mean the notion that if the person is a quote-unquote good guy who's led a respectable life, that means presumptively that the person could not possibly have engaged in an act of sexual violence. And we see this kind of logic with racism as well, that racism is about nasty people, and if the person isn't nasty, therefore they're not racist. I think we need to think about what that might mean. Related point is that sexual violence in this moment is still being conceptualized as exceptional rather than endemic. We think of it as a bad apple problem rather than a problem of power and a problem of culture. I think we need to change how we understand that. There's also an awful lot of false equivalences. Think about the extent to which we equate the harms that flow from the allegation of sexual violence, and there are real harms that flow from that, with the actual experience of sexual violence. Those are not the same thing. And when you listen to people commenting on this particular moment, you get the sense that, we should be equally concerned about the harm that a person might experience as a result of being dubbed a perpetrator with the harms that someone who actually experiences that particular moment. The final thing I will say is that this is also a moment in which we kind of naturalize the extent to which women are going to get a hard time when they come forward. They're just going to get a hard time. Some people think they should get a hard time because we ought not believe them. Some people think that we should believe them because they're getting a hard time. And both of those naturalize the idea that women should get a hard time. And I think it's important for us to recognize the trajectory of sexual violence. At some particular moment, sexual violence was not a crime. It's recent that sexual violence is a crime. That's moment one. Moment two, when sexual violence became a crime, it was not substantively treated seriously. Women were blamed for the acts of violence that they experienced. Moment three, we moved from blaming women to not believing them. Moment four, we have this kind of false equivalency. And moment five, we're moving into this era where something like reverse discrimination is happening, by which I mean, if you take seriously a woman's allegations of sexual violence, that's kind of reverse sexual harassment or something like that. I mean, we need to really think carefully about the extent to which sexual violence is still unspeakable, the extent to which the Me Too movement has an awful lot of work to do, at least in the legal academy and in the legal institution context more generally. My colleague Kimberly Crenshaw wrote an article in the Huffington Post this week on this point, and I urge all of you to take a look at that. My final point is about Anita Hill. What have we learned from Anita Hill? Perhaps we've underlearned. We've learned that perhaps we shouldn't treat women viciously. Imagine that. We've learned that we still don't have to give women a meaningful opportunity to be heard. And those underlearning moments, I think, is part of what we ought to contest about the context in which we find ourselves in.
Terrific. Thank you. Hiroshi, would you? Am I right that your billing sheets were filled with watching Kavanaugh hearings?
And I was getting ready for this evening.
Oh, there you go.
In other ways too.
Do you want to reflect on the hearings and the moment that we're in right now?
Yeah, I mean, to say I want to reflect on them supposes that I can be coherent in a way that it's really hard, I think, for any of us to really come up with things other than thoughts, memories. I've been very upset about this at different levels. I mean, certainly the ones that we've just talked about, but also I've also thought about it from a different angle. I just want to share a bit of this, and we can. And it has to do with what we're doing in law school. It has to do with being a teacher. One of the things about teaching is that it's a very seasonal thing in a certain way. You come back in the fall, and in a way, you build upon the experiences you had before and a sense of history of what you are as a profession and as a legal educator. But you also start fresh, and part of that starting fresh is to really think about what it means in that moment to start law school. And I'm really comparing the moment that we're in now with all that's going on in the court and the Senate and everything else, and maybe in the world, and also how it might have looked even just a year ago in 2017. And I was struck by the fact that when a lot of law students went out to LAX and to protest the Muslim travel entry ban, whatever you want to call it, I remember getting a lot of emails and even calls from graduate students saying, "I want to go to law school." That's going to be what. That's going to be what saves things. And now I was thinking about, so we may be in a moment where the pendulum for a lot of people's minds has swung the other way. And I think certainly the image of the Supreme Court and institutional place may play a role in this. And so this isn't to say, I'm not going to make the argument the Supreme Court isn't important. It is awfully important, but it also made me reflect upon the many other ways in which law matters. There was a panel at the law school just a short time ago about lawyering in this, I guess, in the Trump era or whatever the title of it was. And it really had to do with, the focus really was on impact work. The focus was on impact organizations and what they do in this moment. And I was really struck about two things that I'll share briefly, and then we'll put down the mic. I'll put down the mic. But one is that there is a lot of lawyering going on in this moment that isn't what we call impact work, but it's direct services. I'm on the board of directors of an organization that is working very hard to reunite parents with their children that they've been separated from at the border. And I realized, of course, this is impact work, but it's also day-to-day work that's awfully important, and it continues on. And that's in some ways the lawyering that really contributes to a change or a restoration of confidence in law and in institution. I also thought about the fact that so-called impact work, it isn't just litigation, it isn't just Supreme Court litigation. There's a great deal of work that is done avoiding the Supreme Court, of using litigation in ways that really put it in its place as a vehicle for understanding the rules under which we live, or the culture in which we find ourselves. And the cases that we bring are really just a part of some larger movement. So it made me think about that in trying to contextualize without saying that the Supreme Court is not important. It is awfully important what happens and who the justices are. I don't mean to diminish that, but I also want us to keep in mind that what we do as lawyers and in law school is far broader, and we need to keep that in mind as well.
Yeah, I think what Hiroshi just said makes me think that we ought to spend a few minutes thinking about the federal judiciary as a whole and its response to the age of Trump, because it's very fascinating. There are a number of district judges who, faced with things like the travel ban, the Justice Department's effort to penalize the sanctuary cities and sanctuary states, the effort to undo DACA, that has caused, quite middle of the road federal district judges who've been doing their work quietly for, in some cases, years or decades, to kind of say, this is the moment when I call on my deepest understanding of separation of powers, constitutional structure, individual rights, and I push back. And it's very interesting. There was an opinion earlier in September from a federal district judge in Texas, Judge Hainan, who had been a handpicked judge by Texas and a coalition of red states to kind of push forward the ending of DACA, seeking an injunction. DACA is illegal, it should be enjoined. And he wrote Judge Hainan, I think, totally shocked the people who had handpicked him to be the judge sitting in this case. 80-page opinion less, and saying, DACA doesn't measure up in the Administrative Procedure Act and this and that, and it may be illegal, so on and so on. Gets to the last 5 pages and he says, but I'm not going to enjoin it. I'm looking out there and I'm seeing hundreds of thousands of people who have a vested stake in this matter and who will be hurt by it. And an injunction is a matter of equity. And my sense is I'm not going to do that, at least right now. And I think it, shocked a lot of people and reminds us that there's an awful lot of judging going on other than one First Street Northeast.
No, it's an important point, and it actually brings up the issue of immigration and what was one of, if not the biggest case of the term last year, which was the travel ban case, Hawaii versus Trump. Hiroshi, you were involved in that case in some ways, I understand it, and I was wondering if you could tell us a little bit about the case and why it was so important.
Yeah, thanks. So this really is a very important case, not just in this term, but I think in historical terms. People will be talking about this case for many decades, I think. I think a lot of you know the background of this, but we had 3 versions of executive orders. Actually, the third one is a proclamation officially, and it suspends entry or admission from 6 majority Muslim countries, and also constrains, it also applies to North Korea and Somalia, and in a very limited way to Venezuela. And this was, in many ways, you've heard some people call it the Muslim ban, some people call it the travel ban. That, in a sense, is the nub of the issue. This was challenged and blocked from going into effect by the Fourth Circuit and by the Ninth Circuit, and the case went up. It took months to do this, but in relatively short order, it goes to the Supreme Court. And there's several grounds for challenge. They fall into 2 loose categories. One is statutory, and the other is constitutional. The statutory argument is that this is the president acting beyond the scope of presidential authority, and in particular in conflict with statutory constraints put on in the Immigration and Nationality Act by Congress. And the other is a set of constitutional challenges, and the one that really ends up becoming the one that matters in the Supreme Court is the Establishment Clause. This was very much, chronologically at least, came after the candidate Trump had promised or talked about shutting down the Muslim admissions. There's a lot of stuff on the record, not just as a candidate, but also after coming into office, both personally and through surrogates. There are also challenges based on equal protection and on procedural due process. But so the court ends up deciding this case. The ban is blocked from going into effect. The Supreme Court partially lifts that blockage in the preliminary injunction stage, but it eventually gets the court, which renders a decision 5-4, no surprise, I suppose, on in the last week of June of 2018, this year. And so there's a couple different ways to think about this case, and I'll try to focus on one thing, because I know of course, you could have a 2-day symposium on this one case, so I'm trying to keep this down to 3 minutes here. But there's a couple ways to think about this case, right? I mean, one is kind of narrow and very deep into history. This is the latest in a series of decisions that goes back to 1889 or earlier. And you can think about it that way as an immigration law scholar, and certainly I look at it that way to some extent. But I also think that it's an interesting window into the current moment, and I'm going to just pick one thing about this decision that I think not only gives you an insight into what's going on as an immigration law point of view, but really gives you an insight into what its deeper significance is. And I'm going to loop back, as part of this, to something, Devin, that you said about the exceptionalism of the moment, or the non-exceptionalism of the moment. So it's Justice Roberts writing for majority, and I think it's important to him that this fits within the traditional deference of the judiciary branch to the political branches on immigration issues. This is sometimes called the plenary power doctrine, although that's a term that has all kinds of different and flexible meanings. There's a lot more to say about the reasoning here, but the one I'm going to focus on is his treatment of the racial animus piece of this. There's really a through line of campaign statements, statements in office, and even things that were in the first version of the executive order that suggest this really is a Muslim ban. But what's interesting about this is that is Chief Justice Roberts writing for the majority of 5, declining to rely on that as the basis of saying that this violates the First Amendment by being an anti-Muslim measure and in violation of the Establishment Clause. And it's quite striking the way he does this. He says, essentially, he cites a number of, he says that he talks about the commitment of this country to religious freedom. He says, our presidents, I'm reading here just one sentence, our presidents have frequently used that power to espouse the principles of religious freedom and tolerance on which this nation was founded. And so you think maybe you know that they remanded the decision, they reversed, so you know that it's not going to end up with upholding a plenary injunction, but you think that, he's going to take this very seriously, the animus expressed by the candidate and by the president in office. It says, then he adds, yet it cannot be denied the federal government and presidents who carried out its laws into effect have performed unevenly. And then he basically says, we're going to talk about the office and we're not going to talk about any particular president. And so he imagines, I think, a president who wouldn't say these things, and then he takes the proclamation at face value. So this really implicates the exceptionalism point, right? I mean, he basically says, this is an exceptional moment. We can just let this go, but think more about what the rule must be going forward for cases where our presidents don't perform as unevenly, in the words of Chief Justice Roberts. And so he proceeds really to dismiss the animus claim. Kennedy's concurrence is even more striking because he joins the majority opinion and he goes on and talks about the need to respect the Constitution. And he really admonishes, I think, the president for all of the anti-Muslim sentiments, but then he basically signs on to an opinion and says we can't do anything about it. Sotomayor, there are 4 justices dissenting. There are 2 opinions. Breyer and Kagan, we have 2 justices that really focus and say, we don't know enough the government's relying on a waiver procedure. Let's see how that plays out. And in the meantime, it's important to keep the injunction. But Sotomayor and Ginsburg dissent on the animus grounds. And so what you see there is a very, and they're saying, no, let's not, this is not an exceptional moment. This is the moment in which we have to step up and not treat it as if it's exceptional. And of course, they come out the other way on that basis. And so I just want to flag this not just as an immigration law case, but also as a case that signals two different views, very different views about how to view this presidency. Is this a situation where we distinguish the office of the president and not take seriously the actions of one president and sort of attribute them to the most benign light possible? Or is it one where, as Sotomayor would, in this particular case, was joined by Ginsburg, said, no, this is the moment to step in because it is when these things happen that it is time to step in, and it's not right to treat this as something that is exceptional. I think that's something to look for, because this is not just an important immigration decision, but it is certainly a leading decision from this court in this moment about the reach of the power of the executive branch in any field. And so I think it's important to do that. And the last thing I'll say is that in making that application or in understanding that analogy, the question really is, what work did it do that it was an immigration case? Would this attitude of focusing on the office, would it also apply to a case that did not involve did not involve the border? More to say about that, but I'll stop there.
No, that's a great point. And one of the things that I found really interesting about the Trump versus Why is how sort of the ghost of Korematsu kind of haunts this case. You know, Korematsu, you'll remember, is the Supreme Court decision from the 1940s upholding the exclusion of Japanese Americans and people of Japanese descent from certain areas here on the West Coast. And it lives in infamy in our constitutional law books. Never really cited by anyone for strong authority, for positive authority, because it upholds this clearly racially discriminatory policy, but nonetheless taught every year to law students as an example of how the court has gone wrong and how the court sometimes will defer in moments of crisis or moments of hesitancy that will allow massive rights violations to occur.
And now it's overruled.
Yeah, well, he says, and part of the interesting thing about this case is that clearly there was some conversation about this case behind closed doors and in conference, and in the majority opinion, Chief Justice Roberts says, effectively overruled, says it was wrong the day it was decided. But what's striking is the ways in which the opinion then repeats the mistakes of Korematsu by then, again, adopting a stance of deference and turning a blind eye to what were obvious statements of discriminatory motive. It was one of the things that really struck me about that case.
It's the oddest overturning of a major precedent that I've ever seen. Oh, by the way, it's really, I mean, it's not teed up at all. It's almost a kind of a second thought. And I'll just say one other thing about the Kennedy concurrence. So Kennedy was the fifth vote. And he writes, it's one of the last opinions that we'll ever see that has his name on it. Not the last, but one of the very last. And he's obviously kind of agonizing over it. He knows he's jumping the wrong way. I read it as, of course, you know, then we didn't know upon reading it that he was about to announce his retirement, but it's the work of somebody that has certain instincts in the right direction, but also has major instincts in the other direction, and doesn't have the mental or emotional energy to do what he knows he should do, but he can't do. It's it's only about 4 paragraphs long. It's not really coherent, but it's a kind of it's a painful thing to read.
Mm-hmm. Well, you know, I think the Korematsu case comes up in the opinion, I suspect, because Sotomayor is essentially saying, you're repeating Korematsu. This is a very important part of the decision. And I think Chief Justice Roberts feels compelled, as I certainly would in that instance, to respond to that particular extremely powerful point. And this is the way he not formally overrules it as much as repudiates it or does what he can without the issue being formally in front of the court. There's 2 things to say about that. And one is that if you take, I think it's the next to last, third to last paragraph in the Korematsu majority opinion, take a look at that, because, not now, but I mean, at some point, because if you actually excerpt that, as I think we will in our forthcoming new edition of the casebook, if you excerpt that opinion, that paragraph, you'll see that it's actually reads exactly like Roberts' paragraph justifying the travel ban. You just have to substitute Muslim Americans from Japanese Americans and Muslims from Japanese Americans, actually, I should say. Muslims for Japanese Americans, and you end up in the same sort of thing. So that's just one thing. But the more substantive thing is this. I think that the best case that Korematsu is a different decision, a different case, which is Chief Justice Roberts' point of view, is something along the lines of Korematsu involved citizens, the incarceration of citizens, and that citizens are not the people kept out of the United States. And I think it's interesting and troubling because it really imagines a world in which U.S. citizens don't have foreign family members. And it really separates that line, and it makes you realize the border is doing that much work here. And it's an interesting contrast to the reasoning in cases like Loving versus Virginia or Obergefell, where we don't require people to leave in order to enjoy their constitutional protection of family life. So I just want to say that about Korematsu. It reflects this view that there's a sharp, the reliance on the ability to overrule or repudiate Korematsu in this instance is an example of imagining American citizens without close family members who are in other countries. And it's exactly that latter view of seeing transnational families as lies at the core of Sotomayor relying on Korematsu.
Anne, I wonder if I could turn to you and maybe switch topics a little bit and think a little bit about climate change and the environment and Whither the Court in that space. This past term, there weren't a lot of big cases on the environment or administrative law, a couple smaller ones, but the court has already taken on a new case about habitat protection. Could you tell us a little bit about that case and what it sort of portends for the Endangered Species Act and how the court might go about some of these environmental protection issues going forward?
Sure. Let me just start with an observation that in the environmental area, I think unlike the area involving racial protections and so forth that Devin already spelled out, we're going to see a big shift in how the court deals with environmental cases because Kennedy was the swing vote and he often swung on the side of environmentalists. Not always, but often. And certainly if it's Brett Kavanaugh, we're going to see a big change. We know this because on the D.C. Circuit Court of Appeals, the D.C. Circuit Court of Appeals has direct jurisdiction over a lot of environmental cases, and so he has issued many opinions. And so we have a pretty clear, I think, idea of some of the strains of his thinking in environmental matters. He's not likely to participate in the ESA case, although apparently you don't need to participate in the oral argument, but the tradition has been if you're not there for the oral argument, you don't participate in the final decision. So it may be a 4-4 decision. We don't know yet. There's a bunch of different ways this case could go. So let me just tell you a little bit about what the facts are and why I think it's a little bit hard to predict which direction the court will take. It could be sweeping and it could be narrow. One of the things Justice Kagan said to us yesterday as a faculty is that it was very interesting with a 4-4 composition of the court that the members of the court actually really needed to figure out whether they could find common ground to reach a majority opinion in a way that's not true when you have 9 members, and particularly when you have 9 members who are split so clearly ideologically. So maybe they will find some relatively narrow way to decide this case, but we don't know. So let me tell you a little bit about it. It involves the dusky gopher frog, and that might be important because cuter species tend to get a little more attention and a little more affection legally sometimes than not so cute species, and it's kind of cute. You can look at a picture of it. And the dusty gopher frog used to be all over the southeast of the United States. It now is confined only to Louisiana, and that actually could matter legally. In a moment, I'll tell you why. And these frogs live in ephemeral ponds, and when the ponds dry up, they live in trees. And part of the problem for the frog is true for many, many species, and that is that their habitat has largely been destroyed. So you can imagine ephemeral ponds end up getting covered over, paved over, et cetera, and developed, and the habitat therefore disappears. So the big question in this case is the circumstances under which the U.S. Fish and Wildlife Service, which has jurisdiction over land animals as opposed to marine animals, whether and the circumstances under which it can designate habitat on private land. And in particular here, the U.S. Fish and Wildlife Service designated habitat, critical habitat, on private land where the frog does not live currently. And that's somewhat unusual, and there's special procedures under the statute that allow them to do that. The idea here is the species cannot recover without having appropriate habitat. Some of that habitat still exists, and if we, for example, transfer animals onto that property, they may well have a chance of recovery. Weyerhaeuser owns part of the parcel that was designated and actually leases it out to other tenants. And Weyerhaeuser is arguing that there can be no designation of habitat because it is uninhabitable, because Weyerhaeuser won't let any frogs onto its land. That's essentially their argument about why this should not be designated habitat. But this offers an opportunity actually for the court to do more, right? So the court could interpret the statute in various ways to say that you cannot designate habitat where the species doesn't actually live. That's one question. But buried in all of this is a much bigger issue. I think the court will probably avoid it, particularly with an eight-member court. If it was 9 members, maybe not. And that is, can the United States regulate species that only live in one state, that are intrastate, under the Commerce Clause? And this has been a pet peeve of Justice Roberts in a Court of Appeal decision that he issued in a dissent when he was on the D.C. Circuit Court of Appeals. Weyerhaeuser is saying you need to actually narrowly interpret this to say that we're not covered, or you're going to need to reach the constitutional question. I'd be stunned if they reached the constitutional question, as I said, particularly with only 8 justices, but that is lurking in ESA jurisprudence more generally. One other issue, and then I'll stop and we can come back to climate change, unless you want me to talk about that now, because I think there's some prognostications I can make about what happens if Kavanaugh actually goes on the court. But the other issue here, which will be really interesting, is that one of the intervener environmental groups is arguing that Weyerhaeuser does not have standing to sue. And typically it's exactly the reverse. The environmental groups are challenged as not having standing to sue. And in fact, justices like Roberts have been quite skeptical about environmental standing. Here, the environmentalists are saying there's no injury. They haven't actually been asked to do anything with the species. They're claiming an economic injury, saying that the value of their property has been devalued simply by the designation. But it will be interesting to see. Standing is, I think, one of these issues where the court could significantly move in a direction against environmental plaintiffs, and it'll be interesting to see whether we see some sort of ruling that either is expansive about business interests in standing, or that poses some potential challenges to the court to try to, if they're thinking down the road about whether they want to limit environmental standing, what do they say in this case with respect to a business plaintiff that may, in fact, have difficulty establishing injury in fact?
No, that's really informative, and this is going to be a big, high-profile case. And that Chief Justice Roberts' decision from the D.C. Circuit is one that I've used. Some of my students are here from my constitutional law class. I always do a hypothetical based on the Endangered Species Act and the Commerce Clause for that very purpose. Right?
Can I just say one more thing? I'm just going to echo something that Dean Mnookin said, and that is that Sean Hecht on our faculty worked with 2 students and one of a postgraduate fellow who works with the Emmett Institute in filing an amicus brief on behalf of E.O. Wilson, famous biologist, and a number of other very famous scientists. And the premise of the brief is to argue that U.S. Fish and Wildlife Service should continue to rely on good science in making these decisions, as opposed to, in particular, using kind of dictionary definitions of what constitutes habitat. And interestingly, also I should say here, given how much the Trump administration has come in trying to undo a lot of the environmental policies of the Obama administration, the Justice Department here filed on behalf of U.S. Fish and Wildlife and did not actually reverse positions, and is defending the designation of habitat here. So that's also another interesting part of this case.
That is interesting, and I do want to stick with you. I am curious about the climate change situation and the future there in the Supreme Court. There's been some important rulings over the last few years that have empowered those who are trying to do more to combat greenhouse gases, for instance. If Judge Kavanaugh is appointed to the Supreme Court or someone else who has a relatively similar view, how do you see climate change faring in the future?
So let me start with Judge Kavanaugh, because I think he is distinct from some of the other names on the list because he's on the D.C. Circuit. He's probably distinct for other reasons as well, but let's stick to the environmental questions because the D.C. Circuit hears so many environmental cases and he often opines on them strongly. I think there are a number of principles we can kind of derive from his jurisprudence as an appellate court judge that I think will inform climate change. But let me just step back a moment and just make sure that everybody kind of has a basic understanding of what the court has decided with respect to climate change and why this is going to continue to be such a live issue, in addition to the fact that it is one of the existential crises that our generation and future generations are going to face. It's also got a lot of interesting legal questions. So it starts with Massachusetts versus EPA, which was decided about 10 years ago, and Justice Kennedy is the key vote in that case. And the court does three things that are important. It maybe four. It validates the science of climate change sweepingly in the opinion, again, with four dissenters. It says that states have special solicitude when determining whether you have standing to sue in these environmental cases. And the reason they're going to give special solicitude to states is because states have ceded their sovereign power to the federal government in certain instances for environmental purposes. And so they find standing. And that case easily could have been dismissed on standing grounds. And I think one thing to look at moving forward is what happens to that expansive view of standing in environmental cases, because I could say a lot more about it, but it is kind of technically hard to establish standing for some environmental plaintiffs, particularly in climate change cases, where there are complicated questions involving causation, redressability, even injury. So that's one important point to look at going forward. The other thing Mass versus EPA did is it said that under the Clean Air Act, which is the most expansive and, in my view, the most successful environmental statute, federal statute ever adopted, there were two questions. One was, does the EPA have to determine whether greenhouse gases emitted out of tailpipes of cars endanger public health and welfare? And the court said, yes, the EPA has to determine that. Didn't say they do endanger it, so the EPA has to determine that. The second thing the court said is greenhouse gas emissions are air pollutants under the Clean Air Act. And so therefore, if EPA makes an endangerment finding saying that greenhouse gases endanger public health and welfare, a whole cascade of regulatory requirements then follow, including issuing regulations to regulate greenhouse gases coming out of tailpipes, something that is very much in the news right now and very important to the state of California. There have been several subsequent cases interpreting the degree of power that EPA has to issue pretty sweeping regulations under the Clean Air Act, although the most sweeping regulations have not yet been really litigated. They have been litigated, but they haven't been decided yet by a major court. So let me say a little bit about those. I'll put aside two cases that one of which is quite important because Kavanaugh actually kind of gave the court the intellectual basis for deciding it, and just focus instead right now on two important Obama-era policies that are already in the news and that may make their way up to the court in some form. That's the Clean Power Plan and the tailpipe standards that I just mentioned. Judge Kavanaugh actually heard oral arguments as a D.C. Circuit judge on the Clean Power Plan. He made pretty clear that he's highly suspicious that the expansive nature of that program is consistent with Clean Air Act authority. And so one of the themes out of Kavanaugh's jurisprudence on the environment is very narrow readings of statutory authority to agencies. And one thing I think is interesting is everybody talks about how Kavanaugh is a great kind of proponent of strong executive power. I think that's only in certain areas. I think it's probably not true with respect to agencies interpreting statutes and using their power expansively in ways that he is going to interpret to be much narrower. So the Clean Power Plan, I don't think he can actually decide, and I'm not sure it will make it up to the Supreme Court. But the Trump administration has now issued a notice saying that it's repealing the Clean Power Plan and replacing it with a very narrow rule that essentially allows coal-fired power plants to continue business as usual. Really requires either very small declines in greenhouse gases or, under some interpretations, actually will produce increases in greenhouse gases. And that will, of course, engender significant legal challenge. And I think if Kavanaugh is on the court, we will see Kavanaugh vote to uphold very narrow implementation of the Clean Air Act to say it's perfectly fine not to do very much on climate change. Why does he do that? Because he has pretty strong views that climate change isn't expressly set forth in the Clean Air Act, and that if Congress wants to legislate on climate change, it should come out and say so. You shouldn't be interpreting the statute, this old statute that was passed in 1970, to attack a major problem. So if you think about the major problem, I've got the wrong, it's a doctrine. So there's a major question, sorry, that it's not major problem. Major question doctrine, he's basically saying the Clean Air Act doesn't say anything about climate change. Even if Mass versus EPA has been decided, I'm going to interpret it really narrowly to say, EPA, you can only exercise your power in very limited ways, and we're going to say that it's perfectly fine when you exercise that power in the way that the Trump administration has suggested. Second place we're going to see a big challenge is to the California power to issue its own standards for automobiles, which is also currently under attack. That's assuming the Trump administration goes through with that. And in addition, the Trump administration is trying to freeze tailpipe standards that the Obama administration issued. And I think, again, we're going to see Kavanaugh come in and say climate change isn't actually listed in the Clean Air Act. It's not mentioned anywhere. It's perfectly fine to freeze the standards and to not do very much. So I think it's safe to say that we will see a big shift in the environment. I think it's much harder to say if Kavanaugh is not actually confirmed. The other judges just don't hear very many environmental cases. And so I've tried to kind of get a sense for what some of the other judges whose names are on that list might think about environmental cases, and there's just really not enough to go on.
Devin, another area where there's a lot of transformation happening right now is in the law is the Fourth Amendment. It's an area where the Supreme Court has been taking cases in recent years and offering some new looks about how to deal with questions of searches and seizures, especially in light of new technologies, cell phones and new search techniques. And the Supreme Court had a big case this year, the Carpenter case, dealing with this issue. Can you tell us a little bit about that case and sort of where it fits in this moment for Fourth Amendment law and the transition that law is undertaking?
Yes, certainly. I mean, it's fair to say that the Supreme Court was pretty busy with respect to Fourth Amendment law last term, and Carpenter is just one indication of that. It was a 5-4 case, and it litigates, again, the scope of our Fourth Amendment rights. And to understand precisely what's going on in that case, it's helpful to know a little bit about the broad analytical structure of Fourth Amendment jurisprudence. So starting with the text, the Fourth Amendment protects us from unreasonable searches and seizures, and we can translate that text into 3 broad inquiries. So inquiry 1, is there a search or seizure to begin with? So if what the government does is not a search or seizure, the Fourth Amendment isn't even triggered. So the first move then is to figure out whether governmental action is in fact a search or seizure. The second question is, assuming that what you have is a search or seizure, that doesn't mean that the government has violated the Constitution. Remember, the Fourth Amendment protects us against unreasonable searches and seizures, not seizures, searches and seizures per se. And the question of reasonableness typically turns, not entirely, but somewhat, on whether the government satisfies some prior substantive evidentiary standard. So does the government have reasonable suspicion? Does the government have probable cause? Does the government have a warrant? Those are the kinds of questions we typically ask with respect to figuring out whether the search or seizure is reasonable. The third question is, assuming you have a search or seizure, assuming now that it's unreasonable, what remedial consequences flow from that? And typically, but not always, we're talking about the exclusionary rule. So Carpenter focuses both on the question of whether there's a search and on the question of whether or not that search is reasonable. I'm going to focus my comments on the trigger question, whether in fact there was a search, in the interest of time. So the specific search question in the case is, does governmental access to our cell phone location data trigger the Fourth Amendment in the sense of constituting a search? That's really the question. So presumably you all know this, but anytime you use your cell phone, it connects to a cell tower, and that cell tower marks, among other things, your location. So the question is whether the governmental access to that is a search for purposes of the Fourth Amendment. And the formal black letter test for a search goes back to the 60s. It's a CATS test. And essentially the court asks itself two questions. Question one, do you have a subjective expectation of privacy? And question two, is that expectation of privacy one that society deems to be reasonable? Now, this second question might lead you to believe that the court is going to plumb into our collective consciousness and figure out, well, what do we as a society think is reasonable? That's not, in fact, what the court does. So here I agree entirely with Justice Thomas. This is the only moment I will say I agree entirely with Justice Thomas. But I do agree with him on this point, that the question about whether or not society deems our expectation of privacy as reasonable is really a normative question. It's not an empirical question, and we need to be honest about that. It's fair to say that recently the court has been thinking about the extent to which property law concepts should infuse that inquiry. I'm going to put all of that to one side and keep the analysis simple. Again, so two questions. Do we have a reasonable expectation of privacy subjectively? And is that one that society perceives to be legitimate? So in answering that question, the court turns to two lines of cases. One line of cases is referred to as the third-party doctrine cases, and a second line of cases we might figure or call the kind of surveillance cases, which essentially ask, do we have a reasonable expectation about our whereabouts as we travel through public spaces? With respect to the third-party doctrine cases, the logic goes something like this. If you turn over your information to a third party, you lose your expectation of privacy in that information. So this particular idea was instantiated in a bunch of cases in the 1970s and in 80s, and in particular, one that's called Smith versus Maryland. In that case, the government got access to the numbers that the defendant dialed, and the defendant says, wait a minute, your access to that number, the numbers that I've been dialing, is a search. That's privacy information. Surely that triggers the Fourth Amendment. The court said no. The court said no because, again, that information was turned over to a third party. That became the business record of the company. You assume the risk that that third party would turn that information over to the government. Therefore, it is not a search. It's not a Fourth Amendment moment. That's the logic of that particular case. In this case, the government says, look, that third party argument obtains here. When you use your cell phones, you're turning over data to a third party, the cell company. The cell company turns that information over to the government. There is no search. It's easy. Just apply that basic doctrinal regime, and there is no search. That's not the way Justice Roberts decided the case. Justice Roberts' basic rationale looks something like this. Cell sites render us vulnerable to pervasive and intrusive monitoring because our cell phones are essentially an extension of our bodies. We sleep with our cell phones, wake up with our cell phones, walk with our cell phones, talk to our cell phones. Some of us even shower with our cell phones. In short, our cell phones are us, is the basic idea. And here are some of the more precise ways in which the Chief Justice articulated that point. When the government tracks the location of a cell phone, it achieves near-perfect surveillance, as if it had attached an ankle monitor to the phone user. Quote 2, accessing cell site data is much worse than the quote-unquote noisy neighbor or the intrusive neighbor. Quote 3, cell phone towers are ever alert and their memory is nearly infallible. Quote 4, cell phones effectuate tireless and absolute surveillance. So you get the idea. He's worried about the extent to which cell phones render us vulnerable to various kinds of surveillance practices to the extent that they don't trigger the Fourth Amendment. One more quote, "The accuracy of cell phone location is rapidly approaching GPS level of precision." And the reference to GPS here is significant because in 2012, the court decided a GPS monitoring case in which the court suggested that GPS monitoring can be considered a search. The court did not decide that GPS monitoring is always a search. It's important to point that out. And so Chief Justice Roberts is trading on that particular case here to suggest that access to a cell phone location is kind of like GPS monitoring, and therefore we should think about it as a search. With respect to the third-party doctrine that I described, the Chief Justice says, look, those cases are very different. They don't implicate the kind of mass data storage that characterized the digital age, so we can put those cases to one side. Significantly, he's not saying that that doctrine is dead, he's simply saying that it doesn't apply in the context of this case. And is careful to point out as well that the holding is narrow. It's not the case that any time the government accesses our cell phone location data, that's a search. It is the case that in the context of the facts here, it's a search because the government did so over a 7-day period. So that's the way this case ultimately comes out. It's a moment in which the court is trying to take seriously the implications of digital technology. It's also dealing with precedent that suggests that this wasn't a search, but it's on the other hand not overruling those precedents. They're still a part of Fourth Amendment jurisprudence.
Thank you. And it seems that why do you think the court is able to respond to technology in this way, in the Fourth Amendment? That it's willing to be open-minded in a way that it seems in many doctrines they're not that open-minded about new technologies or new developments in society. Why do you think this is different?
Well, I mean, so the one question I think that applies when you think about the Supreme Court and particularly Fourth Amendment jurisprudence is this. Do we think Supreme Court justices imagine themselves as being vulnerable to the practices that they're describing? They're not going to be racially profiled, so they're not necessarily worried about that, but they might be worried about surveillance on their phones. So there's a way in which they can't easily externalize some of the costs. So that's one way to respond. Another way to respond is that Fourth Amendment jurisprudence is one of the most let's just say it's a site for constitutional mushiness. It really is. We talk about Supreme Court jurisprudence being incredibly indeterminate. That is incredibly true in the domain of Fourth Amendment jurisprudence. So it does have space, it seems to me, to develop in ways that meet the challenges of technological developments. The tricky question is what it will mean going forward. And I say that because there is a move in Fourth Amendment jurisprudence now to kind of take us back to common law notions of what a search and seizure is. This is the point about infusing back into Fourth Amendment jurisprudence the idea that what we're worried about is what was considered a search or a seizure at common law. So there's a battle going on about how to navigate that particular concern, and I'm not sure how it will play itself out.
I think if there's one thing that unites the court's rather incoherent Fourth Amendment jurisprudence, is searches that the justices can imagine themselves being subject to.
Yeah.
And this is true not only in the technology area, not only because they all have smartphones and so on, but even going back a few years, there were a series of cases about random drug checks and searches without probable cause in various locations. And the court was upholding all of them until it got to a bus. Not that the justices were ever going to be taking intercity buses, but the notion that the police could go down through the overhead and kind of feel up the various soft-sided pieces of luggage to see whether they might feel anything that might give them reasonable suspicion. You could just see, I remember attending the oral argument, the justices were thinking of their own luggage and airplanes, and it kind of resonated with them, and I believe it was a Rehnquist opinion that said that that was indeed a Fourth Amendment search.
And along those lines, too, in the GPS monitoring case that Devin mentioned earlier, I remember listening to the oral argument in that case, and Chief Justice Roberts asked a question right at the very beginning of oral argument. The government at the time, the Obama administration, was arguing that they had the right to put a GPS monitor on someone's car and leave it there for an extended period of time and then keep track of everywhere they went. And the Chief Justice said to the advocate, to the Solicitor General, or the Assistant, the Deputy Solicitor General who was there, if your argument is you don't need a warrant, you don't need probable cause to do this, could you put one of these GPS monitors on the cars of the justices and follow the justices everywhere they go? And I remember thinking, I guess that lawyer just lost that case. And it's very much.
And it's analogous to the Riley case that was cited in 2014, where it's the same idea. There, the question, there's a doctrine called search incident to arrest. And the way that doctrine works goes something like this. When you arrest someone, you have the authority automatically to search them. And the question was whether or not that doctrine would extend to the search of a cell phone. You arrest a person, you search the cell phone. The court says, absolutely not. You don't get to exercise that particular authority. And again, it was a moment in which the court could easily internalize the cost as distinct for the many, 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 many moments in which the court is just externalizing costs. This particular kind of intrusive practice is not going to impact me, and therefore I don't have to worry about it.
Linda, I wonder if I could turn our attention now a little bit to the First Amendment in the Supreme Court last year. You already mentioned the Janus case, a very, very important case, one that really will call into question the future viability of public employee unions and may call into doubt even some things that are relevant to some of the people out here, mandatory state bar fees. There's a case being brought up now about whether you can be forced to support your state bar. But there were a number of other big First Amendment cases last year. I was wondering if you could take us through the court on the First Amendment and where do you think the court's going there?
So you're quite right that almost everything the court's been doing in this area, which is to quote Justice Kagan in her dissenting opinion in the Janus labor case, weaponizing the First Amendment as a tool of deregulation, has ramifications far beyond the facts of the individual cases. And one of them that I'll talk about was a case that came down this last term called Tthe against Becerra. Tthe is the National Institute of Family and Life something. So it's a chain of so-called crisis pregnancy centers. These are clinics that, they can sort of advertise, pregnant, need help, come to us. And of course, they're anti-abortion clinics, and they basically exist to persuade you to have the baby. So here in California, the legislature passed a set of obligations on clinics that were in fact licensed as medical clinics, which many of them are not, but that actually have medical personnel on the premises, were obliged under this law to post a notice that says, by the way, if you qualify, you can get free or low-cost, complete reproductive health care from the state of California, including abortion, pregnancy care, maternity care. Call this number. So that was one part of it. For the clinics that have no medical personnel on the premise, they were required to post a sign that says, by the way, dear client, there are no doctors here. This is not a medical clinic. So the challenge to this two-part law really, in my view anyway, raised the question of, can it violate the First Amendment to be required to speak the truth? Okay. And the answer by a vote of 5-4 was yes. In fact, it does violate the First Amendment. So this was a Clarence Thomas opinion. I say 5-4. Justice Kennedy, of course, in the majority, and Justice Kennedy was sort of the biggest First Amendment fan on the court. And, those of us of a certain age who were raised to stand up and salute anytime the First Amendment reared its head over time began to take a slightly more skeptical view of this. So what Justice Thomas says in this opinion was that the required notice is a content-based regulation of speech. And of course, any government obligation for disclosure, whether it's the calorie count or, is this really organic food, or how to wash and wear your clothes, or where the clothes are imported from, or where the beef is imported. I mean, go on and on. So a content-based regulation of speech, a government-drafted script, he says. This is with reference to the requirement for the licensed clinics. He says strict scrutiny has to apply in this case. Now, that was quite a leap, actually, because there's an entire other way to look at this kind of regulation. As Justice Breyer points out in his dissent, there's a line of cases that go under the name of Zauderer. So Zauderer was a case in which the government required a disclosure by lawyers who take cases on contingencies, that disclosure to clients or potential clients that actually you may have to end up paying something about, for your case, even though you're not paying me an hourly fee. That was upheld some years ago as a First Amendment challenge, and under less than strict scrutiny, kind of middle-level scrutiny. And why isn't this the same thing? It's simply a disclosure by the clinic that we're telling you that this is not the only place where you can get help. So why wasn't it something less than strict scrutiny? Why wasn't it indeed government speech? Is something that occurred to me, although maybe I'm wrong about that. The dissent didn't engage with that. But more specifically, why wasn't it covered by Planned Parenthood against Casey? It's not directly an abortion case, but obviously it resonates with the court's abortion jurisprudence. So Planned Parenthood against Casey, as you might remember, upheld a kind of a script in the nature of informed consent, that a doctor, before performing an abortion, was required to do the informed consent. I think in Casey it was 24 hours ahead of the procedure, and had to inform the woman of certain aspects about pregnancy and abortion. And Casey rejected a First Amendment challenge to that. So that was kind of settled law. So we saw, quite a change here. And with the regulation for the unlicensed notice, I think was even a bigger leap, because it was also the unlicensed clinic. Also, the court finds it's unconstitutional to have these clinics just disclose that they were not a medical clinic. So this is the latest, but I'm sure not the last, in a series of cases where the First Amendment has been, as I say, used as a deregulatory tool. Justice Breyer, in dissent, he's been dissenting in these all along the way, saying basically we're seeing the ugly head of Lochner being reared again. Lochner, which was looking at basically economic regulation and coming up with various theories why these regulations had to fall under the First Amendment. So that's the Tthe case. Another case Adam asked me to mention, has been mentioned already, was the Masterpiece Cake Shop case, as a case that didn't lead anywhere, and that's true. That's obviously the case, the baker who wouldn't bake. And I'll say two things about that. One is a Kennedy opinion, and obviously a punt. Justice Kennedy finds in this case that it was a two-part First Amendment case. The baker was claiming First Amendment free speech, not to be forced to bake a cake he didn't want to bake, and also was claiming that religious freedom right, not to have to bake a cake that would violate his religious beliefs. And the court did not address the speech issue, decided it only on the grounds of, interestingly enough, religious animus. So here's a case where religious animus really had actually nothing to do with the case, but the very same court, and separated by a period of only weeks, that finds no animus, that casts a constitutional shadow over the Muslim travel ban case, finds that because one or maybe two members of the Colorado Civil Rights Commission had made the point that invoking religion to discriminate against other people is really a bad thing. They were the lower level deciders in a case that went through then subsequent number of other levels of decision before it reached the Colorado Court of Appeals, which found that indeed the baker was obligated as a public accommodation not to discriminate against this same-sex couple. It's really quite a disconnect between the as they say, the exquisite sensibility about animus in one case and basically ignoring it in the other. That's one thing to say about Masterpiece. The other thing to say is, after deciding Masterpiece, the court granted, vacated, and remanded GVR, another case that had been pending, awaiting a grant of cert, a case called Arlene's Flowers. So Arlene's Flowers is a florist who doesn't want to design a floral arrangement for a same-sex wedding. And there's all kinds of other cases in the pipeline, deliberately in the pipeline by basically recruited plaintiffs who want to press this issue in the wake of Obergefell to kind of claim, a safe space, not to have to deal with gay rights and gay people. So to grant, vacate, and remand Arlene's Flowers in light of Masterpiece Cake Shop is really strange because there's no law made in Masterpiece Cake Shop. So that case will come back, the issue will come back, and we will see it again. And with that, I'll just say the one thing I want to say about the Janus case, and Adam will talk about it from the point of view of doctrine. I think it certainly vies with the travel ban case as the most important case of the last term. And why do I say that? I think doctrinally it's very important as further weaponizing the First Amendment. Its impact is really, really substantial. But beyond that, it tells us something about the heart and soul of the Roberts Court, because this was a case overturning a 40-year-old precedent that was only on the court's docket because one justice, Justice Sam Alito, had basically been crying for, bring me the right case, bring me the right case. This is what I want to do. And the case was cobbled up. It's a phony case. It was first brought by, there are a few cases back, and if Adam wants to tell that story, but in this particular iteration, brought first by the governor of Illinois, whose anti-union campaign had been financed by a shadowy Illinois billionaire who went in and sued against the agency fee, the fair share fee, and was, of course, thrown out of court because he had no standing. He had no injury in fact. He might have had an injury in his, campaign finance budget if he couldn't deliver, but he didn't have standing. So Mr. Janus, the recruited plaintiff, was enabled to intervene and take over the case, which was extremely strange procedurally because once the governor's lawsuit had been dismissed, there was no case into which this guy could intervene, but he was allowed to intervene anyway, and it became the Janus case. So maybe that's all I should say about that.
No, that's great, and I'm actually not going to say too much more about Janus. I mean, I think you've really covered it. I mean, a couple things to recognize out of the case is that the court did overturn a very well-established 40-year-old precedent, the Abood precedent, that allowed public employee unions to collect fair share fees from non-members just to support the collective bargaining, not for political expenditures, but for collective bargaining. And it's a little reminder, I think, for all of us. Most of us have went to law school after Abood was decided or right around then, and we've lived our whole judicial careers with that case being one of those sort of landmark cases that was not really thought to be in question, that was not thought to be likely to be overturned in the near future. And yet it was. There was a slow process to get it to justices who were pushing to do more to overturn it. And I think it's a reminder that when we say that precedent is settled, it doesn't really mean that much in the Supreme Court. The justices really don't take the idea of precedent all that seriously. Although it does seem, one interesting thing that Justice Kagan said when she was here yesterday, she was talking about individual stare decisis. She thought that the justices were more concerned with articulating opinions that were consistent with the prior opinions they had articulated, that they had written. And so it was like an individual stare decisis. They were more. They thought it was important to adhere to their own views more than the views, the settled views of the justices in agreement that have set precedent. And I thought that was a really intriguing distinction that she made. That was, I think, in some ways, kind of troublesome too.
Well, of course, what it means is when a new justice comes onto the court who has no self-stare decisis to worry about, all bets are off.
Yeah, that's right. We are running out of time. We only have a few more minutes. So what I'd like to do is move to the world-famous speed round. And in the speed round, I'm just going to ask each one of our panelists to just talk for 30 seconds about one area of the jurisprudence of the court that they think might be or is likely to be transformed in the direction they might think that's going to go, something that we hadn't already talked about today. Can I start with you, Devin?
May I say no? Yeah, sure. I guess I would say very quickly, it's likely to be the case that we'll have another round of affirmative action jurisprudence. And the thing that I want to remind you of in this respect is that affirmative action has a constitutional birth in a moment of loss. So this year we're marking the 40th anniversary of the Barkey opinion, let's say. And that case was a tremendous loss, even though we're now fighting to keep affirmative action alive, again, from a progressive perspective. But what do I mean by that? That case presented the question of whether or not first, affirmative action would be subject to strict scrutiny. The court said yes. Why? Because the court was, or Justice Powell in that case said yes. Why? Because the idea is that we can't tell the difference between Jim Crow segregation and affirmative action. It's a silly proposition, but it's an idea that had legs. Second, in the context of that case, we rejected the idea of societal discrimination being a thing. The court says that's way too amorphous. That's amorphous. In 1978, when we're struggling with a kind of post-Jim Crow world, the notion is that societal discrimination is not a thing. Third, in the context of that case, the court rejects a number of additional rationales. So the point I want to make here is that affirmative action and other forms of racial remediation are on a lifeline, but it is because of the constitutional terms upon which affirmative action was birthed, and we haven't fully come to terms with that, and we should.
Terrific. Anne?
So I'm going to talk about something really wonky, which is the Chevron doctrine, which has been in the news a lot. I'm not sure everybody understands it when it's kind of popularly reported. I did a radio interview that I thought was the hardest interview I've ever done, trying to figure out what do you say about the Chevron doctrine in a way that is kind of straightforward and short. But I think we are likely to see action on it. I'm not sure we'll see that we'll see it overturned. Brett Kavanaugh would play a very important role here, as would Neil Gorsuch. Gorsuch has actually been more out front about his skepticism about the Chevron doctrine. Let me just quickly remind you what it is. When we're interpreting statutes, if a statute is clear, then the court doesn't need to do anything. That's Chevron step one, deciding that the statute is clear and therefore directs the agency about what it should do. If it's ambiguous, Chevron step two says we defer to the agency's interpretation of the statute as long as it's reasonable. Gorsuch doesn't like it, period. Kavanaugh has actually written an article in the Harvard Law Review reviewing a book where he's quite explicit about what he thinks. He's worried about separation of powers concerns, basically saying, look, we're a court. We're supposed to interpret statutes. We're not supposed to defer to agencies. But the way he has done it so far, and he's done it in 2 environmental cases, is to say, we're just going to tell you what the statute is, even if it's ambiguous. We're going to keep it in step 1. And the best example of this is an environmental case, again, interpreting Massachusetts versus EPA's directive about the Clean Air Act, where EPA was trying to exempt a bunch of small sources from new permitting requirements, even though the statute was explicit that they had to be covered. And Kavanaugh, his reasoning was then adopted by the U.S. Supreme Court, said, even though it's explicit that these sources have to be covered, they don't have to be covered because it doesn't make any sense. And therefore, it's clear that they don't have to be covered, even though it says the opposite in the statute. So I think what we're going to see is the court playing with the language of the statute to interpret it in a way that is consistent with maybe the ideological views of the justices, or maybe with their kind of jurisprudential views about how they think statutes ought to be interpreted, and to get out of the business as much as they can of deferring to agencies. The only other thing I'll say is that I hope Linda will talk about Roe v. Wade.
Hiroshi.
So something I haven't talked about, but I think is going to be coming to the court, is the whole area of sanctuary jurisdictions. It's especially important in California and in other jurisdictions. And there's two ways that this is coming up. One is that the executive branch, the federal administration, is trying to cut off funding to cities that don't comply with cooperation, with local police not cooperating with ICE, for example. And so there's a cutoff of funding, and there's litigation about that that's arisen in San Francisco, Santa Clara County, City of Chicago, City of Philadelphia. That's already been decided in favor of the local jurisdictions by two circuits, the Seventh and Third, and I think it's going to be going up the Ninth Circuit, or decided by the Ninth Circuit. So that's one type of litigation. It's very important. It implicates the spending clause and has to do with whether or not the executive branch has the power to add to restrictions or read restrictions, or how they read restrictions imposed originally by Congress, or is it only for Congress to include those restrictions in appropriations? The other thing, which is also, I think, in the general area of sanctuary jurisdictions, is that the federal government has sued the state of California, and in particular on its so-called sanctuary measures, including a non-cooperation with federal immigration enforcement. And so this is we have a decision out of the district court federal district court in Sacramento, the Eastern District of California. And it's also a sanctuary jurisdiction case, but it arises differently because it has to do with whether or not, or to what extent, non-cooperation by local or state jurisdictions. And, for example, we have a California law, state laws that mandate non-cooperation, whether that in some way impedes federal immigration enforcement, that means that those state and local laws are preempted. So there's more to say about that, but here's just the observation I'll make about how this is not just jurisprudentially interesting, but historically interesting. This is a situation where the federal government's role has flipped completely since the Arizona litigation and other litigation that was earlier in this decade, in 2012, the United States versus Arizona, whereas the federal government saying that SB 1070 in Arizona mandating police detention for people and show me your papers, that went beyond state and local power, and now the federal government saying that you can't do it in sort of a more loosely speaking pro-immigrant or skeptical of enforcement point of view, and now the political situation is flipped. And one of the things that we're seeing in these cases is that the precedents on which the cities and states are relying to protect their prerogatives to preserve sanctuary are actually decisions that were politically quite different in their genesis. For example, two of the principal cases they're going to rely on is the limitation on the Affordable Care Act's and requirements for Medicaid expansion, where Chief Justice Roberts articulates a limit on federal power. This now becomes the state of California's shield. And it really raises this question of why is there a line drawn between state and local jurisdiction on the one hand over immigration issues and federal jurisdiction on the other? Is it some result-oriented line about helping immigrants, not immigrants? Is it a turf line at all? Is it a question of how enforcement should be allocated and monitored? So that's something that's going to. I'm not sure we're going to get a circuit split on the grant issue, but it's a major issue, and certainly when the federal government sues California on something like this, the chances of going to the Supreme Court are significant, and I would look for that.
One area that I'd like to talk about in terms of where we're likely to see growth and change is in the Second Amendment and gun policy. The Supreme Court, as many of you know, has recently read the Second Amendment to protect an individual right to bear arms, but at the same time the court has refused to step back in and call into question laws like bans on military-style rifles, or bans on high-capacity magazines, or bans like that in Los Angeles that effectively restrict people from carrying concealed weapons. And we're not sure exactly why the court has refused to take those cases, but we do know that Justices Alito, Thomas, and Gorsuch have all filed dissents from the denial of cert in those cases. It only takes 4 justices to grant cert. We know there are 3 justices that have been trying to grant cert in these cases. I think a 4th vote from Brett Kavanaugh or whoever it is likely to be the one that pushes the court to take more of these cases. I'm not sure exactly how all these cases are going to come out, because it does depend on where Chief Justice John Roberts fits in this, and I'm not sure exactly how he feels about expansive Second Amendment rights. But I look for the Supreme Court in the coming years to take a number of high-profile Second Amendment cases. I'm going to give, as is appropriate, our final word tonight to Linda Greenhouse.
Well, we're out of time, so I can be very brief in answer to the question of will Roe against Wade be overturned in the coming future of the Roberts Court? My answer is yes.
We call that a mic drop. Thank you very much.